This short presentation has been created to give a general overview of the law in Minnesota on the classification of law enforcement data. Law enforcement data are classified pursuant to the Minnesota Data Practices Act, which is found in Chapter 13 of the Minnesota Statutes. As a general rule, the Minnesota Data Practices Act directs that all government data, including law enforcement data, are presumed to be public. Data are not public only when a state or federal law classifies the data. All government data, including law enforcement data, are classified into one of three categories of access. Public data are available to any person for any reason. Private or non-public data are available only to the data subject, those within the government entity with a work assignment to access the data, other entities that are authorized by statute, or by informed consent from the data subject. Finally, confidential or protected non-public data are available only to those employees within the government entity with a work assignment to access the data, or those entities explicitly authorized by law. The data subject is not entitled to access confidential or protected non-public data. Law enforcement data are classified under Minnesota Statutes, Section 13.82. This section includes any data created, collected, or maintained by any entity that performs a law enforcement function, including local police departments, sheriff's departments, and fire departments. Data collected by other agencies that merely work with law enforcement, such as prosecutors or probation authorities, are not covered by the provisions of Section 13.82. Because law enforcement data are included in the broader definition of government data in the Data Practices Act, all law enforcement data are presumptively public. Section 13.82 classifies some data as always public and some data as not public. The next several slides will detail the most important classifications. First, we will discuss law enforcement data that are always public, regardless of the circumstances or who is the subject of the data. Whenever a member of law enforcement personnel cites, arrests, or otherwise deprives a person of liberty, all data relating to the arrest are presumptively public, even data that are not expressly noted under Subdivision 2. It is important to note, however, that when the data subject is a juvenile, the identifying information about the juvenile is private, specifically the name and last known address. While all data relating to the arrests are presumptively public, some arrest data remain public under all circumstances. This means that, even if the data subject is the subject of an active investigation, some arrest data, including the name, age, sex, and last known address, or in the case of a juvenile, only age and sex, as well as the time and place of the action, the legal basis for the action, and the custody status of the data subject, remain open to the public. Whenever a member of the public requests service from law enforcement, various data regarding the request are always public. This includes the nature of the request or the activity being complained of, the name and address of the individual making the request, with some exceptions that will be discussed later in the presentation, the time and date, and the response initiated and incident response number. Whenever a law enforcement agency responds to a request for service or acts on its own initiative, certain data relating to that action are always public. This includes the date, time, and place of the action, what agencies participated in the action, information on any resistance, pursuit, or use of weapons, and a brief factual summary of the incident. Also note that the names and addresses of victims and witnesses are generally always public, unless the identity of the person in question is protected pursuant to provisions elsewhere in Section 13.82. Such protections are discussed later in this presentation. There are also response or incident data that are specific to traffic accidents. Now that we have established that law enforcement data are presumptively public, and discussed some data that are always public, we will look at some data that are never public, some data that are protected for a certain amount of time, and some data that may not be public at the agency's discretion. When a criminal investigation is active, all data that are not otherwise required to be public, such as certain arrest data, request for service data, or response data, are confidential or protected non-public. As a reminder, this means that the data are inaccessible even to the data subject. When the criminal investigation becomes inactive, the data become public. However, this classification is subject to several exceptions. If the data being requested are part of an inactive investigation and the release would jeopardize another ongoing investigation or would reveal protected identities, such as the identity of an undercover officer or a victim of sexual assault, the data remain private or non-public. Likewise, offensive photographs and financial transaction data remain not public data. Obviously, it is crucial to know when an investigation goes from being active to inactive for the purposes of complying with the Data Practices Act. There are 3 circumstances which definitively render a criminal investigation inactive. They are when the prosecuting authority officially declines to prosecute the case, when the statute of limitations or any deadline to file a charge expires, and when all rights to appeal are exhausted. Because a finding of not guilty is not appealable, such a ruling has the effect of rendering the investigation inactive. As noted above, even when some data are otherwise public, such as data relating to an inactive investigation, law enforcement must protect certain identities as private data. The following identities are to remain private at all times: undercover law enforcement officers, victims or alleged victims of criminal sexual conduct, and mandated reporters of child or vulnerable adult maltreatment. In addition to those identities that must be protected, law enforcement has the responsibility of determining if some identities are to be public or private data. The agency may withhold the identity of paid or unpaid informants if the agency reasonably determines that revealing his or her identity would threaten the informant's personal safety. Likewise, the agency may withhold the identity of the victim or witness of a crime if the victim or witness specifically requests not to be identified publicly, unless the agency determines that revealing the identity of the victim or witness would not threaten the personal safety of the witness. Remember, however, that the identity of a victim of criminal sexual conduct is required to be withheld. The identity of a person making a 911 call may be withheld if the agency believes that revealing the identity may threaten the caller's personal safety, or the object of the call is to receive help in a mental health emergency. Finally, the identity of a juvenile witness may be withheld if the agency believes that the subject matter of an investigation justifies protecting the juvenile's identity. In addition to those exceptions to the general rule that all government data are public, the following information has been deemed not public by the legislature. Data relating to investigations of child abuse, whether active or inactive, are private under Section 1382, Subdivisions 8 and 9. Active or inactive investigative data that relate to the maltreatment of a vulnerable adult are private under Subdivisions 10 and 11. The identity of persons who register complaints with government entities concerning violations of state law or local ordinances concerning the use of real property are classified as confidential pursuant to Section 13.44, Subdivision 1. All data pertaining to the purchase or transfer of firearms, as well as applications for permits to carry, which are collected by government entities, are classified as private pursuant to Section 13.87, Subdivision 2. Data that would reveal the identity of persons who are customers of a licensed pawnbroker are private per Section 1382, Subdivision 27. Various financial information is protected as private, including account numbers per Section 1382, Subdivision 30. Finally, domestic abuse data are confidential until an order for protection is issued and served upon the respondent under Section 13.80. Thank you for viewing this introduction to law enforcement data. Bear in mind that this is only a general overview, and there are a number of other guidelines and requirements in the law that are not covered in this introduction. So please visit DPO's website for more in-depth information, including information regarding all-day workshops on law enforcement data. Also, feel free to contact us when you have specific data practices related questions.